Hello, my name is Eric Willison, and I'm an attorney in the state of Ohio. And in this video, I'm going to talk about lease agreements between landlords and residential tenants in the state of Ohio. I've been practicing in that area since 1996, both on the behalf of landlords and on the behalf of tenants. And so I see the problems that arise between the two pretty fairly between the two. So I'm going to talk today about lease agreements and what you need to think about when you're looking at a lease agreement. Typically, the landlord is going to supply the lease agreement to the tenant, and the lease agreement that that landlord supplies is either going to be written by his attorney, or it may be a standard form lease agreement from a body that would write something like that, like the Columbus Real Estate Professionals Association might put out something along those lines, or the Cleveland Landlords Association. I'm just making these up, but there are organizations that put out standard form leases. But you will also see, however, leases that are put together by attorneys. And what typically the lease agreement from the landlord entails is that it provides the landlord with advantages in every way, shape, and form that it can. Because if the attorney wrote it for the landlord, they're going to make sure that their client is protected and given the advantage in every way that they can. So the first thing that you want to do as a tenant is you want to read the lease agreement very carefully from top to bottom, backwards and forwards, and make sure that you understand it completely. If you don't understand the lease agreement, or you don't understand some provision, a lot of tenants make the mistake of asking the landlord, what does this mean? Well, as an attorney, I always tell my clients, don't take legal advice from the other side. Not a real good idea. If you don't understand the lease agreement, say, well, thank you very much. I'm very interested in your property. I'd like to take this back home and read it over a little bit and talk to an attorney about it to make sure I fully understand it. And then you can go to an attorney's office, and usually they will review a lease for an hour's worth of their time, whatever that charges. There are places like legal aid societies, if you don't have a lot of money, that will do the lease review for you for free. There are attorneys who do things pro bono. If this is a landlord-tenant situation arising in a college situation, oftentimes the college may have a landlord-tenant clinic or a student legal clinic where you can go and have the lease reviewed and explained to you. And once you understand it, then you can go ahead and sign it if you agree with it. But you also want to understand that any clause in that lease agreement is going to be enforced. And it doesn't matter if the landlord and the tenant orally agree to something different. There's something in Ohio called the Parole Evidence Rule. That's P-A-R-O-L. The Parole Evidence Rule means that if there's a lease agreement that says no dogs, but while you were negotiating the lease, the landlord said, don't worry about that. I never enforced that no dogs rule. And then you go and get a dog, and suddenly the landlord says, what are you doing with this dog? The lease says no dogs. And you say, what are you talking about? You said dogs were okay. Well, nope, I'm evicting you for the dog. So then you go to court for the eviction, and the landlord says they're in breach of the lease, Your Honor, because they had a dog, and clause 13 of the lease says no dogs. And you say to the court in response, Your Honor, when I was signing the lease, he said dogs were okay. The court's going to say, sorry, under the Parole Evidence Rule, your testimony about contradictory oral statements that contradict the lease agreement, I can't let them in. They're inadmissible. I'm going to plug my judicial ears as you talk about the dogs and what the landlord said about them, and I'm just not going to listen to it. So that will be no defense under the Parole Evidence Rule to say that, well, the landlord said it was okay, I don't have to worry about that. So if there's a clause in your lease that says one thing that you don't accept, then you must not accept the landlord's explanation that, I don't enforce that clause. Well, if you don't enforce it, then let's mark through it and let's keep going. We'll initial it, we'll mark through it, and everybody will know that we are not going to be enforcing this clause. And if the landlord won't make the change to the lease, then you need to go somewhere else. Another thing to worry about are joint and several liability clauses. That makes every single person who's on the lease jointly and severally liable for all of the acts or inactions of the other that might constitute a breach of the lease. So if you have a lease that's $3,000 a month and you've got 5 roommates and everybody runs out but you are going to be responsible for paying the whole of the rent for the rest of the year. There's also what are called rental acceleration clauses in leases. What that means is that if the lease is breached, the landlord can sue for the entire amount of rent that is due under the lease, even for the months that have not yet come up. So if the lease runs from January 1st until December 31st, and on March 15th, all your roommates run out, and April 1st, only you pay your portion of the rent, the landlord is going to sue for eviction, and he's going to sue for the remainder of the rent due, and he's not just going to sue for April's rent, and then wait again until May and sue again in May. He's going to sue for the entire amount of the rent due through the end of the lease. So you need to think about that as well. There's all sorts of other things you need to think about with leases. You need to look at them and say, is there a clause in here that I will not accept? But then you can compare that to the Landlord Tenant Act of 1974, because the Landlord Tenant Act of 1974 contains certain restrictions on the types of clauses that will be enforced in a rental agreement. For instance, one of the things that the Landlord Tenant Act of 1974 says is that there will be no agreement enforced by the courts of Ohio in residential rental agreements where the tenant has to pay for the landlord's attorney's fees unless it's allowed by the Landlord Tenant Act of 1974. And usually, except in a very few cases, the tenant does not have to pay the landlord's attorney's fees. If the tenant damages the premises under 5321.05, yes, the tenant can be responsible for attorney's fees. But let's say there's no damage, there's just a failure to pay rent, and then the landlord's got a clause 18, let's say, in the in the rental agreement, and that says that the tenants shall pay the landlord's attorney's fees. That is not going to be enforced. Now, it doesn't mean that the lease isn't going to say it, and a lot of tenants don't know their rights, and so they think, oh, gee, I better not sue this, or I better not get into an argument with this landlord in front of the court because I'm going to be responsible for his fees. No, you don't have to worry about that. Also, the Landlord Tenant Act will not allow provisions of the Landlord Tenant Act to be waived. So, if the landlord has a clause in there that says the landlord is not responsible for returning the security deposit, and the security deposit is automatically forfeited at the end of the lease, you don't have to worry about that, because Ohio Revised Code 5321.16, the Security Deposit Recovery Act, says that the landlord must return the security deposit unless there's a reason for the landlord to keep it, maybe unpaid rent or damages to the premises that are in the amount of the security deposit. The landlord cannot, via the lease agreement, just say, sorry, I'm not returning this. That's going to be an unenforceable provision of the lease agreement. So the things to think about when you're talking about lease agreements and looking through them, you have to read them from top to bottom. If the things that you're reading don't make sense to you, you don't understand them, then it's a really good idea to spend a little bit of money and go talk to an attorney rather than have to spend a whole lot of money later and have it explained to you that the damage has been done, there's no way out of it, you've signed this lease, you didn't understand it. The excuse before the court that I read that, Your Honor, but I didn't understand it, that's not going to work. The excuse that, Your Honor, this lease was just shoved in front of me and I never read it, I just signed it, that's not going to work. So you need to read the lease, understand the lease. If you don't like what's in there, make changes. If the landlord won't make changes, walk away.